Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're doing a deep dive on a specific type of injury known as an ulnar nerve injury. And we're going to look at some verdicts and settlements to see what this type of injury is worth. And the reason I'm doing it is because one of the clients, or one of the viewers like you, had texted me and had asked me what I thought his case was worth. And he had an ulnar nerve injury, and he was trying to settle the case himself with the adjuster. And, he made a demand. He was a very knowledgeable, smart individual, made a demand, a very fair demand, for a few $100,000. And unfortunately, the adjuster just lowballed him and offered him like $10,000 and just, refused to negotiate. So at this point, he's thinking about hiring a local attorney, and I may help him find someone if he doesn't know someone on his own. So I just thought it was interesting because he said, look, in addition to that, I looked all over YouTube, I looked online, and I didn't see any videos for this type of injury, which is an ulnar nerve injury. Now, the ulnar nerve is a nerve in your hand that usually there's the radial component and the ulnar component of your hand, and it's usually coming from the, from the elbow down to the wrist. So it's also sometimes going all the way up to the shoulder. So there's something known as brachial plexus, and the ulnar nerve is one of the major nerves in the hand. And there's, of course, different types of injuries. Sometimes you have a complete tear of the nerve where you need surgery. Other times you may have an injury without surgery that you just have pain or symptoms without the need for surgery. So of course, every injury is going to be different and the values are going to be different. But let's get into it. Here's a case. Now, these cases are from New York, where I'm licensed. I'm going to try to also get access to a few other databases where I could look at cases all over the country. But this particular case, these cases are from New York. And here's one case, and this was a case in Orange County, which is a bit upstate New York. And it was a verdict. It was a trial verdict. And what happened here was it was a premises liability case. And so a lady, she was 65 years old. She was at a property that had a parking lot, and the property was owned by this motel. And so she was caused to slip and fall to the ground. And she suffered a fracture of her left elbow. And one of those the fracture that she suffered caused an ulnar nerve damage. And that resulted in a permanent claw hand deformity. So this was a serious injury. And so she sued saying that there was a defective condition in the driveway of this motel. And the defendants claimed that the incident occurred on a sunny day, so any alleged defective condition was open and obvious. And they said the plaintiff had lived at the premises for over 2 years. So if she lived there that long, well, then she should have known about it, right? And this was her fault. And the defendants claimed the plaintiff was negligent in failing to use reasonable caution to avoid an open and obvious hazard that she was aware of. And so this case actually went to a jury verdict. And the verdict was $1,500,000. So I think that was a pretty good verdict for the plaintiff. They have their attorneys, local attorneys from upstate New York. I've heard of them. I think they have a good reputation. And they had an expert, an orthopedic doctor. And so this was in 2022. Okay, let's go to the next case. The next case is a case from 2021, and this is also upstate. This was a case where an 8-year-old slipped and fell in a puddle of water near an ice machine in a grocery store. So it was against ShopRite, supermarkets. And he sustained a humerus fracture, and he had ulnar nerve damage. It doesn't give specifics. It just says he had ulnar nerve damage in this particular report. And he actually had to, here's more information. He had to undergo transitional nerve replacement surgery, and he still felt tingling and numbness, and he could no longer participate in gymnastics or cheerleading, could no longer play the violin, and was diagnosed with possible complex regional pain syndrome. So that's a pretty serious that's a pretty serious injury to this child, to this girl. And plus she had surgical scarring. So she sued through her mother and natural guardian, and she argued that the defendants were negligent in allowing an accumulation of water near this ice machine and failing to inspect the area, allowing a dangerous condition to exist for an unreasonable period of time, and so failing to clean, cover, or remedy the accumulation of water, and that this was the cause of her permanent injuries. And the defendants basically argued that the plaintiff assumed the risk, and that's what it said, contributory negligence. I guess they were saying the kid was at fault for slipping on the ice. I don't know. The parties reached a settlement. So this was a settlement that was reached, and the settlement was for $650,000. So also not a bad settlement. Seems a little light, you know, for those kind of injuries with surgery. The first case didn't even mention surgery. So seems a little light perhaps, but still significant. Still significant, $650,000. The third case is from 2019, and this is in the Bronx. And what happened here was a 13-year-old boy suffered a fracture of the left distal humerus that required open reduction and internal fixation. And he had ulnar nerve subcutaneous transposition surgery when he was on the premises of a Sky Zone indoor trampoline park. And so what happened here was he fell off a Skyline apparatus. So he argued the defendants were responsible for his damages and that there was an agreement. You know, he signed one of those agreements that he's not going to sue, but he said that was void because it was not signed on the date of the incident, and it was signed by, not signed by his parent, and it was ambiguous in general. And the defendants denied liability and argued that a participation agreement, which was signed on the infant plaintiff's behalf, precluded his claims. And so this case was settled for $135,000. So it was a little bit light. I think maybe the plaintiffs were afraid that this waiver that they signed was going to be effective, and that's why they settled it for a smaller amount. I'm not sure. We also don't know exactly what happened because according to this description, it just says that he fell off an apparatus, but we don't know what apparatus, what was wrong with it, what was the defective condition. You know, in order to really gauge value, you'd have to know the liability. Obviously, the liability is a huge component of what a case will be worth. Okay, the next case is a case in Erie County that's up north as well. And here a 28-year-old woman suffered injuries, including ulnar nerve damage, closed head injury, disc protrusions, and a right hand finger fracture, a rotator cuff injury. And so she was a passenger in a tow truck, and the tow truck struck a concrete center median head on. So the plaintiff argued that the driver of the tow truck was negligent in failing to maintain control of the truck, and and that the company was negligent in failing to maintain the truck. And the defendants denied liability, disputed the extent of the injuries, and contended the plaintiff failed to mitigate her damages because she didn't wear a seatbelt. And so, given these injuries, the case actually went to trial, I believe. Let me see here. Yeah, it went to trial, and the verdict was for $3 million. So pretty good verdict in Erie County. That's up in Buffalo, but a nice verdict, I would say. $3 million. Yeah, pretty good verdict. I mean, she did have some serious injuries, but yeah. Okay, here's another case. This one is from 2018. And this is from New York County, which is Manhattan, which is New York City. Okay, let's see what happened in this case. This case was a male construction worker suffered injuries to his left forearm, and he suffered cuts to the radial and ulnar nerves and arteries and had loss of use of his forearm. And this happened when he slipped and fell on a roof that had a substance similar to sand on its waterproof membrane, causing him to slide into a sharp metal flashing on a building under the ownership of a defendant who was the owner of the building. And so, yeah, so this was under the labor law 241-6, and he relied on some industrial code regulations with respect to railings and other protections. So the jurors actually gave 20% to a group, I guess some kind of a management group, 45% to this other company, and 30% to another company. So I guess there were different companies that were involved with this building. And then 5% of blame went to the plaintiff. And the grand total amount that the jury allowed for was $262,747.60. And it actually broke down that past damages totaled $257,747.60, and future damages, this was all for pain and suffering, future damages were only $5,000. So that's just kind of like a low damages case for the injuries, but you know, we don't know all the details. Here's another case. This one is in Richmond County. Now, Richmond County is Staten Island. That tends to be more of a conservative venue. Here you have a man who was an adult, suffered left knee damage, ulnar nerve lesions, and some herniations in his neck and mid-back. And they happened when the vehicle that he was driving was struck by a vehicle owned and operated by the defendants. And the plaintiff argued that the defendants were negligent in the ownership and operation of their vehicle. The damages were disputed. And ultimately, in this case, they had a high-low, which means that, they had parameters. It doesn't say what the high-low was, but they had a high-low. And ultimately, after a jury trial, the jury in this case found for the defendant, and they allowed for 0. But because there was a high-low, the plaintiff recovered the low. So he still got something. It doesn't say how much the high-low was. But yeah, Staten Island is a tough venue. You have to really, spend a little more time picking the right jury out there. Here's a case in Suffolk County, which is way out east, out in the Hamptons and out there. And here, a 12-year-old suffered a fractured right elbow at the ulna and radial head, which required 3 stitches, including internal fixation, and ulnar nerve palsy. And she was playing in the backyard trampoline, attempting to do a somersault in someone else's home. And then they argued that the defendant stayed inside the home and failed to supervise the group of boys they knew to be playing on their backyard trampoline. The defendants denied liability, claimed assumption of the risk, noting that the infant had been on the trampoline many times before, and this was just an unfortunate accident. And the parties settled this case, and they settled for $300,000. So this was against like the homeowners, but let's say trampoline. Doesn't say there was anything wrong with the trampoline. It was more like just that the parents didn't supervise. But trampolines are dangerous, and you got to be careful. 12-year-old boy, trampoline. That could lead to an accident. Okay, the next case is in Queens. And this case, let's see what happened in this case. 10-year-old female reportedly suffered a right supracondylar humeral fracture and a 25% neurological deficit caused by a radial and ulnar nerve palsy as she participated in a rock climbing activity on the premises managed and controlled by YMCA of Greater New York, Flushing. And she fell 6 feet to the ground. One of the defendant's employees tugged on the rope attached to the rock climbing harness she was wearing. The plaintiff argued the defendants were negligent for permitting the premises to remain in a dangerous condition, for failing to inspect, for failing to repair, and for creating an obstruction. The defendants denied liability, and this case settled for $225,000. So this was a settlement. The next case is again from Erie County. And here we have a 40-year-old female who was a nurse who had an ulnar nerve injury. It just says injuries to the ulnar nerve in her right arm, wrist, and hand when her vehicle was struck by an automobile operated by the defendant individual near an intersection. The plaintiff argued that the defendant's negligence had caused the accident and her resulting injuries and damages due to the defendant's failing to maintain control over her automobile while driving at an excessive rate of speed, failing to maintain a proper and safe distance from other vehicles, things like that. It's just basic, rules of the road type stuff, like not being careful. And the defendant denied liability and argued the nature and extent of the plaintiff's injuries were not caused by this accident and were just not serious. And the jury reached a verdict for the defendant. This time they gave 0. And this was also in Erie, so also up in Buffalo. And let me see. Here's one from Nassau County, also a conservative venue. That's Long Island, but more like closer to Queens, Long Island, New York. Here, an adult female suffered a right ulnar nerve laceration, right 4th and 5th digitorium superficialis and flexor digitorium profundus lacerations, right ulnar neuromesis lesion at the wrist, and right medial partial axonal loss and emotional distress while she was on a real property owned and operated and controlled by the defendants. Her hand was caused to go through the glass of a common area window that she was attempting to open, and the plaintiff alleged the defendant's negligent, careless, and reckless conduct, specifically allowing an unsafe trap-like condition to exist, failing to inspect the premises for dangerous hazards, failing to properly remedy the existing hazard, and failing to warn invitees, people who are invited to come into this building, of any, warn them of existing damage, caused the subject incident and her damages. So the defendants denied any negligence or liability, and the jury found that the defendants were not negligent and awarded nothing. So again, a tough venue. So I guess they didn't, I don't know what the danger was with the window. It doesn't say specifically, but the jury didn't buy it. Let's see what other cases we have with ulnar nerve injuries. Here is a case that involved bilateral carpal tunnel. Now, this was a federal court case. This is in the Eastern District of New York. And the case was an adult male. He was an employee of an airline, and he was guiding a catering truck on an airport tarmac near a luggage conveyor. And he sustained a concussion leading to post-concussion syndrome, cervical and lumbosacral vertebral derangement, disc herniations, L3 and L4, as well as C2 and C3. That's the cervical, the neck, and the lumbar. Cervical and lumbar myofascial pain. But he also had radiculopathy in the lower back, but he also had bilateral ulnar nerve entrapment at the elbow and carpal tunnel entrapment at both wrists when he was struck in the head by a piece of luggage tossed by an agent employee of the Aircraft Service International. And so the plaintiff argued that the defendant aircraft was negligent under a vicarious liability theory because the employee didn't follow the policies of not throwing bags onto a belt loader for fear that luggage might tumble off. The plaintiff also argued that the defendant was negligent for failing to maintain a proper lookout for tarmac workers, failing to warn of potential danger, and the defendant denied the allegations and argued that any unsafe condition was open and obvious, and the plaintiff had actual or constructive knowledge of any hazard. And so in this case, there was a verdict. So it was a jury verdict, and the verdict was for $347,738. So pretty good, not a bad verdict. Not huge, but something, because federal court is tough. So getting anything in federal court is always a win. Let me see if I know which attorney handled this. Oh yeah, this was a good attorney in Manhattan that I'm familiar with. Yeah, very, very skilled attorney. So yeah, so he got, and I kind of know some of the doctors as well that are involved. I've used some, I actually know the plaintiff and the defense doctors on this case. Yeah, so good job. Oh, and another judge. I had a case with this same judge a few years back, and our case settled for, I think, $1 million, or right under $1 million, maybe $975,000. It was a fusion case. We had this. He's a very good judge. So I know everybody in this case. So good job for everybody. That's a good result in federal court. Federal court is tough. Okay. Here's a case. This is in Suffolk County again. And this was an adult woman who had a laceration of her right small finger and ulnar nerve and required surgery, resulting in permanent injuries. A blade fell out of a food processor when she was looking at food processors with her boyfriend at Bed Bath & Beyond. And so she had, the defendant actually had allegedly turned the food processor on its side, causing the blade to fall out. The plaintiff argued that Bed Bath & Beyond was negligent in operating, maintaining, supervising, repairing, and or inspecting the premises, its appurtenances, displays, merchandise, and fixtures, and she further claimed that the defendant negligently displayed the food processor with its blades. She claimed the defendant negligently caused and or allowed a blade to fall out of the food processor, turned over the food processor, failed to take adequate precautionary measures to protect the plaintiff. So basically it was negligent. And then the defendant denied in saying the plaintiff was solely at fault for her injuries and that she assumed the risk and the condition was obvious and they had no duty to warn. And so the end result in this case, let me see what happened. There was a settlement, and the settlement was for $28,500. It's a kind of a light settlement, kind of a light settlement, but I guess they were saying it was a laceration of a finger. So, but an ulnar nerve laceration requiring surgery, you'd think would be worth more, but maybe the liability wasn't that good. It's hard to say. Sometimes it's hard to tell from the description. They keep the descriptions kind of short. Let me go through this list to see if there are any other interesting cases. I don't want to go through all the cases. Sometimes when you do a search, it'll return like 100 cases. You can't go through all 100 of them. But just quickly, here's one in the Bronx. This one settled for $97,500. It was an ulnar nerve injury to a boy who was playing basketball and he tripped in an uneven rubber mat. Here's a case from, again, from up in Orange County. And it was a plaintiff verdict for $105,000, and that was for an ulnar nerve in the right elbow injury. And I think it was, she also went to a store operated by Cumberland Farms, slipped and fell due to some water in the aisle by the refrigerator. So, yeah, that's not bad, $105,000. But it was ulnar nerve in the right elbow, distal radius fracture of the left wrist, a torn rotator cuff, and it required arthroscopic surgery. So actually, maybe that is, well, up there, maybe up there they go for less value. In New York, that would be low, but up there, maybe that's not a bad verdict. Here's a Queens verdict. Actually, I'm sorry, this is a Queens settlement, and this one was $112,500, and it was an ulnar nerve in the right wrist that required an ulnar nerve repair, nerve graft surgery with scarring and lacerations in the surgery. This was a boy, 14 years old, pushing a door open, and the glass on the door shattered. Those cases are tough, unless you can get an expert and they show, hey, something's wrong, they're just going to argue, look, you punched the door. I've had cases like that. They're always going to argue you punched the door. But they are supposed to have shatterproof glass, but, you got to have some kind of defect, something they did wrong. Otherwise, they're tough cases. Here's another defense verdict in Suffolk. And then in Orange County, a $75,000 settlement. And then in Erie County, a defense verdict. But you kind of get the sense that they're worth anywhere from, into the millions. I think we had 2 cases in the millions, right? 1.5 and 3. Those were more serious. And usually they go for anywhere from 75, 100. And if it's more serious, maybe 150 to 300 in that ballpark. Which is kind of along the lines of this particular YouTube viewer. He was asking for about 200, but the adjuster only gave him 10,000, and she was, dismissive, very dismissive, not willing to be fair and not willing to negotiate a case in good faith. And, he was a little bit surprised, but look, you can't be surprised because that's what insurance companies do. That's why you need a lawyer to go in there and get you the fair value of what the case is really worth. Okay, I hope this was helpful. Actually, let me do one more case. Here's a case. This is in Kings County, which is Brooklyn. And an 11-year-old suffered severe lacerations to their face and left arm, including complete transections of his ulnar nerve ulnar artery and 6 tendons and an avulsion of his nose. Ooh. He was playing in the lobby of his apartment building, lost balance, and fell into a glass panel next to the front entrance door, which was installed by a glass company. And the glass broke into large, sharp shards upon the plaintiff, and the plaintiff argued the defendant was negligent, failing to install safety glass, failing to maintain the premises in a safe condition. The defendant denied liability, and this was a settlement, and the settlement was for $850,000. I'm just going to go through it quickly to see if there are any other interesting cases, any other big ones. I don't really see anything. I see a defense, 350, 75. Here's another defense verdict. Oh, here's one for 2.1 million. Maybe we'll do this one and we could end on this one. This was up in, where was this? What does it say? This is a construction accident. And this was a worker was cut by plywood and he claimed a disabling nerve injury. And this was, oh, this was in the civil court. Okay, so this was New York City. This was in Manhattan. And this was a 38-year-old electrician mechanic working at a construction site that was located at 7 World Trade Center. And during the course of his work, he was struck by plywood that had fallen from an upper floor, and he sustained an arm injury. And so the arm injury included neuropathy of the left arm's ulnar nerve. And he had a surgical decompression and transposition of his left arm's ulnar nerve. And so he was diagnosed with reflex sympathetic dystrophy, which is a chronic neurological condition that is typically characterized by severe burning pain, pathological change of bone and skin, excessive perspiration, swollen tissue, and increased sensitivity to physical stimuli. The syndrome is kind of now called complex regional pain syndrome. So he had that complex regional pain syndrome as a result of the ulnar nerve surgery. And he underwent administration of pain-relieving ganglion block injections. He underwent a radiofrequency sympathectomy, which involved the removal of inflamed nerves, underwent temporary implantation of a device that stimulated his spinal cord. Oh, so he had a lot of injuries. Yeah, really serious. And it was also a construction accident, 241 and 240 and 241-6 case, falling object case. And the case ended up settling for $2,150,000. Which for all those injuries is kind of not that much, because that's a really serious injury. And here's another one. Sorry, I'm getting some of the good stuff now towards the end. Here's another one for $1.75 million. And this one was in the Bronx. It was also an iron worker who sustained ulnar nerve transections of the left ulnar nerve and left ulnar artery. So that's pretty serious. And what happened to him was he was installing steel panels on structures on the roof that were housing mechanical, plumbing, and electrical maintenance stations. And at one point, his foreman asked him to enter one of the structures to help push into place a steel panel. He slipped on ice on the rooftop, fell on his left wrist, and was cut by a piece of galvanized angle that was frozen in the ice. Ooh, that's pretty serious too. Okay, I'm just gonna go through a few others. I don't see anything too interesting. Some more basic cases. But yeah, I mean, ulnar nerve cases can be very, very, significant depending on the severity of the injury. The more severe the injury, and plus, you can't look at the ulnar nerve case by itself, right? Because oftentimes you have an ulnar nerve injury, but you also have other injuries that are with it. So you have to look at the total injury to the client. Okay, I hope this was helpful. Let us know what questions you have. We are here for you. Please like and subscribe to our channel. If you leave us a comment, we'll answer your comment, maybe do a video about it where we discuss it in our Last Week Tonight episode where we answer your questions and comments. Join us live and we can answer your question live. And in addition to that, if you need a private consultation, just text me 347-566-9595 and I'm happy to text with you or schedule a call and offer some guidance. Okay, Thank you, everyone. Have a great night, and we will speak to you very soon. Bye-bye.